So, hi everyone, good evening. Let's start with today's session. So, today in this session, we'll be taking a glimpse of all the important legal affairs which happened between 1st to 7th of June 2026. Right, so let's start with today's session now. Right, now the first judgment that we have to discuss in this particular session is actually really important because it is related to women empowerment. So you might say that it is one very important judgment with social perspective. So in this particular case, the Honorable Supreme Court of India has basically upheld that married daughters are also eligible for the compassionate appointment. Now students, what do we understand by the term compassionate appointment? Anyone who'd like to answer the question, what is compassionate appointment? Compassionate appointment. Right. So it is a kind of social welfare scheme, compassionate appointment, where um, it's a kind of social welfare scheme, and it is available to the dependents of public servants. I mean, if while the public servant or while the person was holding that particular office, and while in the office he basically lost his life, or there are certain medical grounds due to which he could not serve the services anymore, then that dependent are actually allowed to get that particular job, right? Or to get a job for which they have eligibility, right? I mean, obviously there are certain jobs which require technical expertise, so in that particular segment you can say that it is not purely applicable, but हाँ, जिस चीज को आप डिजर्व करते होंगे compassionate appointment में वो आपको मिलेगा. And through this particular judgment, the Honorable Supreme Court of India has overturned the view of Allahabad High Court. Now, अभी तक क्या था कि जो मैरिड डॉटर्स थी उनको जो कंपैशनेट ग्राउंड्स पर अपॉइंटमेंट होता है वो अवेलेबल नहीं था उत्तर प्रदेश में, एंड ऑन 2nd of June द सुप्रीम कोर्ट ऑफ इंडिया डिसाइडेड टू सेट असाइड दिस पर्टिकुलर वर्डिक्ट ऑफ द ऑनरेबल Allahabad High Court delivered in the case of Kusum Nisha versus State of UP. Now, the reasoning given by the Supreme Court of India is also of great importance because it said that by not providing an opportunity to the married daughters, we are violating, or the Allahabad High Court was violating Article 14 and 15 of the Indian Constitution. And we know this Article 14 and 15 are the parts of the fundamental rights. So in that particular context also, this is extremely... Ma'am, sir, ma'am, what's your take on changes in exam pattern? Okay, fine. We'll discuss that as well. Just wait for a minute. Let's talk about this first session now, which is important for your examination. The Supreme Court on June 2 set aside, so we know this, High Court judgments which held that the definition of family doesn't include a married daughter for the purpose of compassionate appointment. So this was the current, position of the Allahabad High Court, that Allahabad High Court believed that married daughters are basically, they are not the part of the family. मतलब अगर फादर ने उनकी शादी कर दी एंड ही इज इन शी इज लिविंग विद हर इन लॉज, सो नाउ as per the opinion of the Allahabad High Court, for the purpose of compassionate appointment, that married woman was not eligible for the compassionate appointment. A bench comprising Justice P.S. Narasimha and Justice Alok Aradhe held that it is in agreement with all the judgments of the Bombay High Court. So before setting aside the judgment of the Allahabad High Court, the Honorable Supreme Court of India has cited verdict from the different high courts like Bombay High Court, Karnataka High Court, Calcutta High Court, which had said that marital status can't constitute a valid ground for denying the welfare measure to an otherwise eligible daughter, right? So the Supreme Court of India has also made it absolutely clear through various judgments of the various high court that with the first and the foremost thing that we have to understand, that the marital status ki, your marital status is married or not married, it will not define whether you are eligible for the job on a compassionate ground or not, right? The marital status can't constitute a valid ground for denying the welfare measures to an otherwise eligible daughter. Agar wahi daughter married nahi hoti, then she was eligible, but once she is married, तो ऐसा क्या स्पेसिफिक चेंज आ गया कि वो कंपैशनेट ग्राउंड के लिए या कंपैशनेट ग्राउंड्स पे अपॉइंटमेंट के लिए एलिजिबल नहीं है. नाउ इट फर्दर हेल्ड दैट द एक्सक्लूजन violates article 14 and 15 clause 1 of the Indian constitution. So article 14, basically we know this, article 14 talks about right to equality, whereas article 15 students prohibits discrimination on the basis of race, religion, caste, sex and place of birth. So, and we know this fundamental rights are only enforceable against the state. So, it is the responsibility of the state to ensure the availability of the fundamental rights for everyone. So, if the state is denying that the compassion, married daughter cannot get a job on the compassionate ground, then it is certainly the violation of Article 14 and 15, because Article 14 talks about right to equality, whereas Article 15 prohibits discrimination on the basis of various grounds. Now, moving on to the next important point, the Supreme Court said the relevant considerations are dependency, financial need, residence, and the ability of the applicant to discharge the obligation attached to the dealership. So, finally, the Supreme Court of India has also given a very prudent reasoning that why the Supreme Court of India is allowing a married daughter to get a job on the compassionate grounds. So the relevant considerations. So basically, the Supreme Court had said it doesn't matter. It's not relevant. The marital status of the woman is not relevant. The only thing which is relevant for the consideration of for a job on the basis of compassionate grounds are basically dependency. What are the financial needs of that married daughter, where she is residing, and also when you get a job on the compassionate ground, तो आपके पास में बहुत सारी एडिशनल रिस्पॉन्सिबिलिटी भी आ जाती है. टेक वन एग्जांपल दैट सपोज your father was in the job and your mother was dependent on your father, and now your father is no more, or he's not able to serve the office because of some medical reasons. Then once you have taken job on that on the compassionate ground, then you have to uh, discharge certain responsibilities towards your mother as well. So that is also one of the considerations while allowing a married daughter for a compassionate job, that whether she is applicable or whether she is eligible or whether she is in a situation to discharge the obligation which are attached to that particular compassionate appointment. Marital status bears no rational nexus to any of these considerations. The judgment authored by Justice Arathe states that the exclusion is based on the premise that a married daughter ceases to be a member of the family. Such an assumption, however, is not constitutionally permissible. The bench said that the marriage neither extinguishes the bond between a daughter and her parental family, nor furnishes a valid basis to presume absence of dependency. So, I mean, again, we do understand this particular point, and for so many years, this particular position has been made absolutely clear by the Honorable Supreme Court of India in itself, that what if SC/ST changes their religion? So basically, let's understand. So if you are not if you do not profess Hinduism, Buddhism, and Sikhism, and from Hinduism you convert to Christianity, and you are and the concerned person is of belongs to scheduled caste, then the very moment you renounce your religion, from Hinduism, Buddhism, or Sikhism, and you opt out for any other religion, your status of scheduled caste would be gone. And we discussed this particular judgment in in last week as well. Chintala Anand versus State of Andhra Pradesh, where a person who was SC, he converted to Christianity. Then there were certain kind of assault against him. So he filed charges against SC/ST Act. SC/ST Atrocities Act. So finally, the Supreme Court of India held that once you convert from Hinduism, Buddhism, and Sikhism to any other religion, your status of SC is gone, right? And status of ST does not change, so it is not applicable in that particular context as well. Hello everyone, let's keep ourselves focused on this particular discussion, and this is going to be a very good session. I mean, you will thoroughly enjoy it, because you will connect to a lot of topics happening things around you. So this was the first judgment which we discussed, and it was delivered in the case of Kusum Nisha versus State of UP. And in this particular case, the Honorable Supreme Court of India set aside an important judgment pronounced by the Allahabad High Court. And Allahabad High Court basically held that the married women are not allowed job on a compassionate ground, because the view adopted by the Allahabad High Court was that once a daughter is married, she is not a member of the parental family. So the Supreme Court of India set aside this particular opinion of the Allahabad High Court, and it said that the marital status will not decide the bond of a daughter with her parental family, and she is absolutely eligible for the job on the compassionate ground. Now, last week we had a discussion about this particular topic, and whenever we discuss about this particular topic, the issue is related to Aravali Hills, right? So last year in November and December 2025, there were two different judgments from the Honorable Supreme Court of India, and both these two judgments created a lot of panic in the society, right? So the first judgment was delivered in the month of November 2025, when Justice B.R. Gavai was the Chief Justice of India. So what happened, students, that when Justice B.R. Gavai delivered that particular verdict, he gave a definition of Aravali Hills. Right, and in this particular judgment, Justice B.R. Gavai said that any land formation above the height of 100 meter, above the height of 100 meters would not be considered as part of Aravali Hills. Now, once this particular judgment was pronounced by the Honorable Supreme Court of India in the last week, or I guess in the second last week of November 2025, there was a pan-India protest. And why this protest was there? Because as soon as the Supreme Court of India set aside, a guiding line that any land formation which is above the height of 100 meter any land formation which is above the height of 100 meter would only be considered as पार्ट ऑफ अरावली हिल्स. तो इससे क्या हुआ कि जो बिलो 100 मीटर के लैंड फॉर्मेशंस थे वो क्या हुए, दे प्रोन टू लॉट ऑफ माइनिंग एंड एवरीथिंग. सो इससे क्या हुआ कि जो नेचुरल फीचर्स थे अरावली हिल्स के, वो सारे के सारे क्या होते, खत्म हो जाते, राइट. सो आफ्टर दिस पर्टिकुलर जजमेंट वाज प्रोनाउंस्ड बाय जस्टिस बी आर गवाई दैट एनी लैंड फॉर्मेशन which is below the height of 100 meter would not be considered as a part of Aravali Hills. Any land formation which is above the height of 100 meters would not be considered as the part of Aravali Hills. And after this particular judgment, there was a pan-India protest. So what happened that in the same month, Justice Suryakant became the Chief Justice of India, and he basically set aside the judgment. And he basically ordered to constitute an expert committee and to provide a fresh definition of Aravali Hills. Now this is the timeline. Now this not the timeline exactly. If you look at these two cases, you will understand one thing, that after the Supreme Court of India said that any land formation which is below the height of 100 meters, as per the Supreme Court, it is not the part of the Aravali Hills. And after the pan-India protest, the Supreme Court set aside its own order delivered in the month of November. It said that will constitute a fresh expert committee, and this fresh expert committee will provide a concrete definition of the Aravali Hills. Now the members of this particular committee has been finally finalized, have been decided. So that's why we are discussing about this particular topic. So let's start with our discussion. So this particular order was passed in the case of in re definition of Aravali Hills and range and ancillary issues. And why it is written in re का मतलब होता है इन द रेफरेंस ऑफ और इन द केस ऑफ. मोस्टली ये नॉमेनक्लेचर आपको वहां पर दिखा हुआ मिलेगा किसी केस के सामने, जिस केस का सुप्रीम कोर्ट ने सुओ मोटो कॉग्निजेंस लिया होता है, वहां पे आपको हमेशा इन रे मोस्ट ऑफ जगह पे देखने को मिलेगा, ठीक है. सो द सुप्रीम कोर्ट हैज कॉन्स्टिट्यूटेड अ 5 member हाई पावर्ड एक्सपर्ट कमिटी टू अंडरटेक the comprehensive review of issues relating to the definition and demarcation of the Aravali Hills and ranges, observing that decision with the far-reaching environmental consequences should not be taken without the benefit of the expert evaluation. So finally, the bench uh, headed by Justice Suryakant, which ordered the constitution of a committee, has also said that without taking the considerations of the expert committee, we cannot provide a benefit of doubt at the cost of the environmental consequences, right? And to serve this particular purpose, the Honorable Supreme Court of India took the suo moto cognizance जब पूरे इंडिया में प्रोटेस्ट होने लगा था, ठीक है. Now a bench comprising Chief Justice of India, Justice Jomla Bagchi, and Justice Vipul M. Pancholi. So this particular case is taken into consideration by these three judges: Chief Justice of India Suryakant, Justice Suryakant, Justice Jomla Bagchi, and Justice Vipul M. Pancholi. Passed the order in the suo moto proceedings. I have already told you that it was a suo moto cognizance taken by the Supreme Court of India by utilizing the powers given in Article 142, right? By utilizing the powers given under Article 142. Now, moving on to the next aspect of this particular article, the court noted that it had earlier expressed the need for an independent expert assessment of a report submitted on October 3, 2025. सिर्फ October 3, 2025 को जब expert committee ने अपनी report submit की, उसके बाद November 2025 में Justice B.R. Gawai's bench said that any land formation which is above the or which is below the height of 100 meter would not be considered as a part of Aravali Hills. And after that, there was a pan-India protest. Then a bench headed by Justice Suryakant took the suo moto of cognizance and decided to constitute a fresh committee to redefine the Aravali Hills, right? Now abhi Aravali Hills ke bare mein kuch basic facts hain. You need to have a strong grip over these facts. The first one is Aravali Hills spread across 4 states: Delhi, Haryana, Rajasthan and Gujarat. Second point, maximum part of Aravali Hills is in Rajasthan and the maximum peak is also in Rajasthan. It is known as Guru Shikhar Peak. It's on Mount Abu, right? So these are ancillary facts related to this particular topic. You should have a grip over this particular topic as well. Now students, moving on to the next point, I hope you have written all these informations, because this is again that is the objective of all these sessions, that we keep on tracking all the important things. Now moving on to the next point. So the committee has also been asked with examining concern that 1048 out of 12,081 hills in Rajasthan meet the prescribed 100 meter elevation threshold. So I mean, this was the main reason why there was a pan India protest, क्योंकि अगर जो November 2025 में judgment दिया गया था, अगर वो judgment survive कर जाता, तो out of 12,081 hills which are the part of the Aravali Hills, उसमें से सिर्फ 1048 hills ही ऐसी होती जो ये 100 मीटर के threshold को cross कर पाते. The committee will be headed by ex officio by the Director General of the Indian Council of Forestry Research and Education. Its member includes, so first would be the chairperson, and he would be the ex officio Director General of the Indian Council of Forestry Research and Education. The second and the following members are Dr. Subhas Ashutosh, former Director General of the Forestry Survey of India; Dr. Rajendra Kumar Sharma, former Director of the Geological Survey of India. Then we have Brij Mohan Singh Rathore, former Joint Secretary in the Ministry of Environment. Then we have Dr. Ashok Kumar Bhatnagar, former head of the Department of Botany at Delhi University. So this is the composition of this expert committee, which has been tasked with redefining Aravali Hills. The committee has been directed to submit its comprehensive report. So deadline has been also issued by the Honorable Supreme Court of India that this committee has to submit its report by 31st of August 2026, after taking all the considerations, after taking due diligence, and after conducting a very deep research. They have to inform the Supreme Court of India by 31st of March 2026 that what should be the new definition of the Aravali Hills, and the Supreme Court of India will take consideration of this particular matter in on 7th of September 2026. Right, now moving on to the, we have already covered two important topics for the day. The first one was related to the jobs, the availability of jobs for the married women on the compassionate grounds, and the second one was related to the constitution of an expert committee for redefining Aravali Hills, and this particular committee has been tasked with to submit its report before 31st of August 2026, and subsequently the Supreme Court of India will take up this matter on September 7th 2026. So these are the two topics that we have covered. Now we'll move comprehensively towards the third topic. Now, this is also very important judgment because last year the Parliament of India passed a very important piece of legislation which is known as um, Prohibition of Online Gaming Act, right? So now there was a case in the Honorable Supreme Court of India, and this particular case was basically students related to two different piece of legislations for enacted by the government of Tamil Nadu and the government of Karnataka, and these enactment or these laws were brought by these two states to prohibit online betting and wagering on games. Right, basically क्योंकि these two states felt that a lot of people are becoming unnecessary victim of the online gaming and betting. So that's why they brought these two, these two states brought laws to prohibit online betting and wagering on games. And finally, there was a company, Jungly Games India Private Limited and others versus connected cases. So all these companies filed a case against the state governments. Basically, they wanted this particular act to be quashed by the Honorable Supreme Court of India, and the reasoning given by the Supreme Court of India is absolutely outstanding, and you will understand each and every point very comprehensively. But we have to cover this topic very meticulously because each and every point related to this discussed in this particular article is very important, because mostly जो article discuss किया गया, that article is a part of fundamental rights. So that's why this topic is more relevant for you at this point of time. So the first one is a bench of Justice J.B. Pardiwala and Justice R. Mahadevan held that states have power to regulate and prohibit betting on games of skill under entry 34 of list 2 of the 7th schedule. So let's talk about 7th schedule as well. Now, students, let's talk about 7th schedule, and with that we'll move to the next point. We'll move to the next point. Entry 34 of list 2 of the 7th schedule. Right. So a bench of Justice J.B. Pardiwala and Justice R. Mahadevan held that states have power to regulate and prohibit betting on games of skill under entry 34 of list 2 of the 7th schedule. So let's talk about 7th schedule a bit, and then we'll move to the next point. We'll move to entry 34, which exclusively talks about the betting of online gaming. So basically, students, 7th schedule of the Indian Constitution talks about the principle of federalism. And what is federalism, students? So federalism is basically division of power. And the next important point related to federalism is that Supreme Court of India in SR Bommai versus Union of India has upheld that federalism is the part of basic structure and it cannot be changed. Now moving on to the next point, students. So this division of power is clearly manifested in the 7th schedule. And what is this manifestation? So this manifestation is basically done through 3 lists. There are 3 lists: union list, which is known as list 1. Then we have state list, which is known as list 2. And then finally we have concurrent list, which is known as list 3. Now union list the entries. So there are different entries. यूनियन लिस्ट में जो एंट्रीज हैं उस पर सिर्फ और सिर्फ पार्लियामेंट ऑफ इंडिया लॉ बना सकता है. स्टेट लिस्ट में जो एंट्रीज हैं उस पर सिर्फ और सिर्फ स्टेट गवर्नमेंट लॉ बना सकती है. और कॉन्करेंट लिस्ट में जो एंट्रीज हैं उस पर सिर्फ और सिर्फ बेसिक कॉन्करेंट लिस्ट में स्टेट और सेंट्रल दोनों ही एम्पावर्ड होते हैं लॉ बनाने के लिए. बट स्टेट लिस्ट एंड यूनियन लिस्ट आर म्यूचुअली एक्सक्लूसिव. बोथ दीज ऑर्गन्स कैन नॉट इंटरफेयर इन ईच अदर्स डोमेन. सो लिस्ट वन we know, list 2, so basically entry 34 of list 2. And what is entry 3 of list 2? Anyone? It is related to online gaming and betting. What is list 2? Anyone? List 2 entry number 34. So entry 34 is exclusively related to betting and gambling, right? So right, so what is this idea of entry 34? So basically entry 34 empowers any state government कि वो किसी भी तरीके की taxation policy रख सकते हैं when it comes to online gaming and betting. वो किसी भी तरीके का guidelines set कर सकते हैं, वो किसी भी तरीके की gambling activities को prohibit कर सकते हैं. And why the reference of entry number 34 of list 2 was given? The idea was really simple. The idea was really simple, so that if a state wants to prohibit online gaming and betting in their state, they can do so. If a particular state wants to have a different kind of taxation policy on the betting and gambling, then also that particular state can do so, because it is directly related to the state revenue, right? So now moving on to the next point. You can also drop your questions in the chat box section. I'll be more than happy to answer your questions as well. So now the Supreme Court had said entry 34 of list 2 of the 7th schedule of the Constitution, which empowers state to legislate on betting and gambling. The constitutional protection available to games of skills does not extend to wagering or betting conducted on such games, the court held. So court has also held the constitutional protection available to games of skill. So basically there is a constitutional protection to the games of skill. Basically वो protected है under article 19(1)(g), वो profession, right to profess, practice any trade or business of your choice. But this particular constitutional protection is not extended or is not applicable to the games जो wagering involve करते हैं. And what is wagering? Something which is dependent on happening and non-happening of something, that is called a wagering event. So wagering और betting conduct वाले जो गेम होते हैं या उस नेचर की जो चीजें होती हैं उस पर जो constitutional protection available है, that is not extendable. So this was the first logic given by the Honorable Supreme Court of India. The second one was the court also held that the online gaming companies do not have a fundamental right under Article 19 Clause 1 Subclause G to carry out any trade involving betting and gambling. So Article 19 Clause 1 Subclause G students gives ultimate authority to the to any individual. And when we say individual, it basically Article 19 Clause 1 Subclause G also includes this particular right is available to every Indian citizen. And Article 19 Clause 1 Clause G is absolutely clear on one point, that every Indian citizen has freedom to practice any profession or to carry out any occupation, trade or profession. So चार चीजों का right है. आप कोई भी profession pursue कर सकते हैं, आप कोई भी occupation, trade या business कर सकते हैं. But if that trade or business is involving betting and gambling, then that is not protected under Article 19 Clause 1 Subclause G. You may start an online betting application, you may start an online gambling platform, and then when you are before the court of law, then you cannot say that I have been protected under the Constitution of India. There is a constitutional protection available to me under Article 19 Clause 1 Subclause G, because it allows every citizen to carry out trade, business and occupation of their own choice. Then the Supreme Court of India will answer that, look, mister, this constitutional protection is not available to the games involve betting and gambling. Skill of games involving skills are different from online betting and gambling. As far as the connection of the online gaming companies that the legislation violates their fundamental rights under Article 19 Clause 1 Subclause G is concerned, it has to be rejected at the outset for the simple reason that once, and what is that reason? That once that trade being carried out by the companies is classified as a betting and gambling enterprise, it becomes res extra commercium. Now, what is res extra commercium? Anyone? This highlighted magazine. Res extra commercium. Res means two things. Commercial means commercial activities. Res extra. Extra means outside. Things outside commercial trade. Things outside commercial activities or commercial trade. Right? Things false or things outside. Res extra commercium means things outside commercial activities. So once a particular enterprise is involved in online gaming and betting, then this particular protection of Article 19 Clause 1 Subclause G is over because of a Latin maxim which says this. There is a concept called res extra commercium which says this: anything which is not a commercial activity, so it will not be considered as a commercial activity and you cannot profess it anymore. So the question of applicability of Article 19 does not arise. The court held the finding in the impunged judgments that the expression betting and gambling ought to be interpreted as betting on gambling is a clear constitutional aberration, tinkering with the constitution or actually rewriting the constitutional text, which courts are not legally entitled to do, the court held. Because rewriting of the constitution or making a specific piece of legislation, it's purely the domain of the parliament or state legislative assembly. So the Constitution of India cannot rewrite something and will interpret as per their own terms and conditions. So basically in this particular judgment, the Supreme Court have made it absolutely clear that betting and gambling is one term. It should not be interpreted as betting on gambling. अब betting और gambling जब हम बात करते हैं स्टूडेंट्स, तो हम यहाँ पर हम दो अलग अलग एक्टिविटीज की बात कर रहे हैं, ठीक है, बेटिंग एंड गैम्बलिंग. लेकिन जब हम बेटिंग ऑन गैम्बलिंग की बात कर रहे हैं, तो इसका मतलब क्या? देयर इज एन एक्टिविटी विच इज टेकिंग प्लेस and betting is taking place on that activity, taking place on the basis of the outcome of that activity. So that is betting on gambling, right? So betting and gambling are two different kind of activities, but betting on gambling is something where only one outcome. Betting में you can win or lose, gambling में you can win or lose, but यहाँ पर gambling is an activity जिस पर betting हो रही है. So the Supreme Court of India had said the constitution should not be rewritten and interpreted. It is, the term is betting and gambling only. The Supreme Court held that the constitution does not deprive states of the power to regulate or prohibit betting merely because the betting takes place on a game that predominantly involves skill. The court clarified that although games of skill may not themselves amount to gambling, betting on such games does not automatically enjoy constitutional immunity, right? So basically the Supreme Court had said कि जो गेम ऑफ स्किल्स होते हैं, जो गेम ऑफ स्किल्स होते हैं, उस गेम ऑफ स्किल्स पे आप बेटिंग कर रहे हैं या नहीं कर रहे हैं, गैम्बलिंग कर रहे हैं या नहीं कर रहे हैं, दैट इज ऑल टुगेदर अ डिफरेंट थिंग. बट जो गेम या जो एक्टिविटीज जो अपने आप में गैम्बलिंग और बेटिंग कॉन्स्टिट्यूट कर रही हैं, उन पर हम किसी भी तरीके का कॉन्स्टिट्यूशनल प्रोटेक्शन अवेलेबल नहीं करवा सकते हैं. गेटिंग माई पॉइंट? जो गेम ऑफ स्किल्स होता है, वो गेम ऑफ स्किल्स इज एन एक्टिविटी. उस पर कोई वेजर करना चाहता है या नहीं करना चाहता है, दैट इज वेरी सब्जेक्टिव. So there you can have the protection of the constitutional protection of Article 19 Clause 1 Subclause G. But betting and gambling themselves are such kind of activities, or they have such characteristics that it is quite implicit that the involvement of money is always there, and that is the main objective of the government or the legislature, to prohibit people from participating in these kinds of games, and so that it can stop people from spending their hard money on these kind of cases, right? Now moving on to the next point. Apart from entry 34, the court held that the states could also draw legislative support from entry 1 of list 2 relating to public order. The court observed that the impact of online betting and gambling in the digital age extend beyond individual participants and can affect broader societal interests, thereby justifying state intervention. And it is also quite possible, right, that there's an area, and people of that particular area are very prone to online gaming and betting, and and somehow they lost a lot of money on these gaming platforms. So what will happen? They will eventually they will disturb the public order. You may go for education loan as well. I mean, that is one suggestion, because I also took education loan when I went to BHU, so you can have that, you can exercise that option as well. So this is one thing. Now moving on to the next point. I hope you are getting my point. I hope you are understanding each and everything, because this session is absolutely related to the important topics related to CLAT 2027 and 2028 as well, right? So because all the most of the articles that we have discussed in today's session are basically the part of they are basically related to your part 3 of the chapter 3 of the Indian Constitution, which is fundamental rights. Fundamental right is also a part of static GK in current affairs and general knowledge, and it is also a very important aspect of your legal reasoning, right? So that's why these articles are very important. The first article was discussing article 14 and 15. Then the second article was related to the definition of Aravali Hills. It might be a relevant point फॉर स्टैटिक जीके, जिसमें हम सबसे ऊंची पीक का नाम क्या, कितने साल पुराने हैं, राइट? 100 million years old, one of the oldest mountain in our country, right? So these are the facts which might be relevant. Highest peak is Guru Shikhar peak, which is on Mount Abu. It is spread across 4 states, right? And the maximum portion of Aravali Hills is in Rajasthan. Then we have another important judgment related to federalism and related to the Prohibition of Online Gaming Act. Some context was there, but it was specifically related to 2 different pieces of legislation passed by Telangana and Karnataka prohibiting online gaming and betting, and the different companies contended in the Supreme Court that this is the violation of Article 19 Clause 1 Subclause G. Then the Supreme Court said no. There is a difference between games of skills and betting and gambling, because the companies were contending that betting and gambling involve a certain level of skills. So Supreme Court said कि जो skill के game होते हैं उस पर betting करना, gambling करना is optional thing, but betting और gaming अपने आप में activities involved होती है जहाँ पर एक consideration money की हमेशा involved रहती है, right? So these are the 4 judgments which we have discussed, 3 judgments which we have discussed. Now moving on to the fourth one. Dr. Jaya Thakur versus Government of India and others. So basically, a month or 2 months back, the Honorable Supreme Court of India delivered a very historic judgment in the case of Dr. Jaya Thakur versus Government of India. Now, while pronouncing this particular judgment, the Honorable Supreme Court said that menstrual hygiene is a fundamental right under Article 21. So, Dr. Jaya Thakur versus Government of India became that popular verdict which upheld or which established a very a very important right of important right under Article 21, where it recognized menstrual health to be a part of Article 21. Now students, the next important point is that when this Honorable Supreme Court of India pronounced the judgment in the case of Dr. Jaya Thakur versus Government of India, it laid down so many guidelines for different institutions that how they have to ensure menstrual hygiene, that there should be different dustbins these sanitary pads, right? And then also the Supreme Court held that all these educational institute must have a stock pile of sanitary pads. अगर किसी को अचानक से periods आते हैं, so the school must have these pads, and there should be separate toilet for the women and girls within the educational institutions, right? So basically all these things were done by the Honorable Supreme Court of India to provide better menstrual hygiene, because menstrual hygiene is one of the main reasons for so many infections in women, right? So basically, and it is also something where the state should provide certain level of guarantees to uh, the women. So the Supreme Court on Monday directed that the union government to address shortcomings in the implementation of its direction on menstrual hygiene and management in school, observing that menstrual hygiene has been recognized as a fundamental right flowing from Article 21 of the Constitution, and that a mere declaration of the right would not suffice without effective ground level implementation, right? So I mean, the judgment was already delivered by the Honorable Supreme Court of India, I guess, in the month of April. And while pronouncing this judgment, the Honorable Supreme Court of India laid down multiple guidelines. So finally the Supreme Court of India has said that there are so many shortcomings when these directions of the Supreme Court are being implemented. So the union government has to address each kind of shortcomings and will have to ensure that there are proper facilities in the educational institutions, because the Honorable Supreme Court of India has held that menstrual hygiene is a part of Article 21, right to life, and fundamental rights are enforceable against the state. So a state has to ensure that the guidelines issued by the Honorable Supreme Court of India are properly implemented, right? So this is about today's session. I guess I hope you would have loved or liked this particular session. अगर किसी ने नहीं देखा तो मेरा सजेशन यही है कि आज के जो चारों ऑब्जर्वेशंस थी, these four observations are very important, and these observations are basically from 1st of June to 6th of June 2026. And you may write down all the static aspect, all the static GK involved, like you may write down articles for your polity for your Indian polity preparation, and you can also jot down a specific observation made by the Honorable Supreme Court of India. You will have a better reasoning capability while solving legal reasoning, right? So this is all about today's session. Thank you so much, guys. I mean, you can take a loan, and that's one thing. So what's your take on the changes in the exam pattern? We'll come back to you on that. What's our take on the recent changes made by the Consortium of NLUs, or that report? I mean, I don't know the current status of that report, the report of the expert panel which was constituted earlier, right? So this is all about today's session. Thank you so much, guys. You're lovely, and we'll see you tomorrow at 7:45 in the morning for the daily Hindu analysis. Tomorrow we'll have another quiz of 10 questions at the end of the class. So let's stay connected and stay motivated. You still have approximately how many days? Approximately 181, 182 days before CLAT 2027. So just invest every drop and every drop of blood and sweat into this examination. This is totally worth it. This examination might change the course of your life. Nobody knows. No one knows the future. Future is always uncertain. So on that note, I wish you all the best. We'll see you tomorrow morning at 7:45. Till then, just take a good care of yourself and people around you. Bye everyone. Bye.